Yes, hello, good evening.
Good evening.
Please introduce yourself.
So my name is Farha Nishat. I'm from Jahanabad, Bihar. I've done my schooling from Bihar School Examination Board, and I've done my law graduation from Hidayatullah National University, New Raipur, Chhattisgarh. I have a brief experience of working in the Honorable Supreme Court of India as a law clerk cum research assistant, and this is my first attempt.
All right. So you have mentioned that you have completed your law from Hidayatullah National Law University, right? In which place it is located?
So it's in Raipur, New Raipur, Chhattisgarh.
What is the famous thing in Raipur? What you have came across?
So when we were there was not much, but a nearby place is there, Ghadi Chowk, and
Mhm.
it is famous as a landmark building only. There's a famous clock in the city, and
Okay.
around the places, so there is a tiger reserve. If I'm not wrong, the newly built tiger reserve, and I can't recall anything else. Sir.
Okay, so you can't recall anything else. All right. And what was the year when you have completed?
So 2018.
2018 you have completed.
Yes, sir.
Okay. And thereafter, I believe you have mentioned that you have worked as an clerk come research assistant in
Yes, sir.
Honorable Supreme Court. So what was your work over there?
So we mainly used to prepare briefs for regular matters, miscellaneous matters, and then
Mhm.
thereafter anything the research work that were given by the honorable judges to us, we used to do that. Then when there is judgment writing, we used to prepare the pleadings, the fact and contention of the judgment, and thereafter the honorable judges would carry on with the law points.
Under which judge you have done this?
So two judges. First was Honorable Justice R. Bhanumati ma'am. I was with ma'am for 2 years up until ma'am's retirement. Thereafter, I had worked with Honorable Justice Ajay Rastogi sir for 9 months. Sorry, 10 months, and both of them have been retired now, sir.
Okay. All right. So what you have learned, please tell me three things that you have learned in this.
In- So I have learned the nuisance of the research work. What are the attributes a research assistant could possess, and through that I have tried to better my learning skills, judgment writing skills, and I have seen. And the other thing would be, sir, that the court proceeding. I have closely watched how the Honorable Supreme Court works, and the third would be that ma'am had always, Bhanumati ma'am had always emphasized on the power of reading various judgments, novels, etc. The power of reading. So I have included that in my daily life, sir.
All right. So, you have learned that how the Honorable Supreme Court has worked, right?
Yes.
The working, the procedure. So, how it's going to help you once you will be a judge in subordinate judiciary?
So the Honorable Justice R. Bhanumati ma'am is one of those judges who have been gone to the Honorable Supreme Court of India from district judges. So she has also always uh, taught us how a district judge should, what the attributes a district judge should have, the uh, the minute things that one should check.
No, you will not be a district judge, right? You will be a chief, you will be judicial magistrate first class.
Yes, sir.
So, how that procedure which you have learned, which you have experienced in the Honorable Supreme Court would help you in this?
So by district judge, I meant the subordinate judiciary itself, and through that, as in how a petition should be, uh, uh, how a plaint should be studied thoroughly, and there is actually a ma'am's book around it, the working of subordinate judiciary. So that is I have
Okay. And you
read.
have also mentioned that you are having a keen interest in reading the books, right?
Yes,
So,
yes.
what all genre you are having an interest? What kind of books you read?
So mostly thriller Thriller
Okay.
genre is good. Yes, sir. And mainly law. The novel which are based on law. I enjoy reading that as well, sir.
Can you name any novel, three or two novels based on Indian laws?
Indian laws. So
Yes.
lastly I read John Grisham's The Summons. I did not have not read yet. There is a book that I have been reading, but I've only gone through first case of it. This is the book is written by Mr. Chintan Chandrachud on the cases that India has forgotten.
India has forgotten. India has forgotten. What was the essence of that novel?
So those were the judgment. I've only gone through one judgment, so I could tell you about that. There was the judgment of Keshav Singh, in which 28, a full High Court judge, 28 judges bench have been sat on the point of parliamentary privilege, the breach of parliamentary privilege, sir.
Breach of parliamentary privilege. What do you
Privilege, yes.
understand by this breach of parliamentary privilege? What is privileges according to you?
The privileges means something that that cannot be questioned by anyone. A conduct which cannot be questioned by anyone. But parliamentary privilege is whatever happens in the parliament should not be called upon, or should not the thing should not be published outside, or should not be called upon any judicial review unless it's absolutely necessary to do so.
Whether privileges are also given in some statutory laws, and if yes, can you name it?
So there is section 105 for regarding article 105 for parliamentary privileges, but there are no specific statutes regarding it, sir.
Okay. And what about privileged communication?
Privileged communication has been mentioned in Indian Evidence Act, sir, for various persons, such as the spouses, for judicial magistrate, between lawyers and the client privilege, sir. The public documents, sir, which are sensitive in nature, that is also privileged.
Okay. So, Farah, what are your hobbies?
So
One hobby you have mentioned that you like to read books, right?
I like to read books. I like to watch series, and in my free time, sir, I teach underprivileged children, sir.
Okay. All right. That's a good thing. Okay. And according to you, what is happiness?
Happiness. So I believe that happiness is what leaves you content.
What
It
gives?
could what leaves you content
Okay.
after doing it. If you feel content, I believe it's happiness, sir.
Whether India is a happy state?
I don't think so, sir. No.
Why?
So I believe that there are many things we as a country are lacking. Uh, it has two facets, a good side as well, a bad side as well. If we focus on the bad side, I believe that there is so much of uh, gender discrimination. There is poverty, underdevelopment. These could the things that I believe that we are yet to achieve.
Okay. Okay. All right. Okay. And Farah, now please let us come back to the law point, right? And what are your areas of interest in law?
So I like reading CPC as a concept wise. I like CPC, but I like to apply the constitutional law in reading aspects. I like constitution. I like reading about
What do
it.
you mean by SLP, and in which situation SLP can be filed?
So SLP has been mentioned under Article 136 of the Constitution of India. It says that generally, when a law has to go to all the way to the Honorable Supreme Court of India, there is a need of certification from High Court that case includes substantial question of law that needs to be decided by the Honorable Court. But in certain circumstances, the applicant or the petitioner can directly go against any order or decree to the Honorable Supreme Court of India, asking for leave to appeal in the Honorable Supreme Court, and if it is admitted, it would be turned into criminal or civil appeal, respectively, whatever the matter it is.
So for that, the certification is required from the High
No,
Court.
sir. No, sir. It doesn't.
So the certificate which you have mentioned, that is required under which situation and under which article?
So if the matter has been decided by the High Court and the party wants to go to the Honorable Supreme Court of India to file second appeal or something, then certification is required. I'm unable to recall the certification article, sir.
All right. What you have also mentioned second appeal. What do you mean by second appeal and under which provision we can find it in CPC?
So second appeal means when the first appeal of the uh, party have been dismissed, or the party are not content with the outcome that has been come from the first appeal, then they could go to the Honorable Supreme Court of India for second appeal.
To
And
Honorable
the Supreme Court of India, sir.
Supreme Court of India. Okay.
Yes, sir. So, and under CPC, it has been mentioned under Section 100.
Section 100 says that you can directly go to the Honorable Supreme Court of India in second
No,
appeal.
sir. After getting the certification from the High Court, directly. No, sir.
Okay. Okay. All right. Okay. And since you have mentioned that you are having keen interest in reading CPC, right? So I'll ask you a question. What do you understand by the term double jeopardy?
So double jeopardy means okay, so double jeopardy means a person should not be vexed twice for the same cause of action. So if a person has been heard substantially on a matter, then that person cannot be called upon in another court of law on the same cause of action.
Okay.
I
Provisions.
believe it's not in CPC. It would be in the form of res judicata under Section 11.
Yeah, that is true. Tell me the provisions related to double jeopardy.
Okay, so there is in the sorry, in the Constitution of India, it would be under Article 20, Clause 2. Under CRPC, it would be under Section 300. In CPC, it would be under Section 11.
What
And in
is
Indian Evidence Act, it would be Section 40.
okay? What is res judicata?
The res judicata is a facet of this, sir, that if a person has been heard substantially and the matter has been decided by a competent court on any matter, on any issue, that issue cannot be dragged upon in another competent court on the same cause of action, sir, by the same
Whether res
parties.
judicata applies upon criminal cases also
Yes, sir.
directly?
Under Section 300 of CRPC, it says 300 of CRPC.
Okay. What is the difference between Article 20 Clause 2 and Section 300?
So, Section 300 talks about acquittal and conviction, both. But when the outcome is only of conviction, that has been mentioned under Article 20, Clause 2.
I'll give you one situation, Ms. Farah. Suppose that there is one person who has gone to a party and over there he has voluntarily intoxicated himself. And the level of intoxication was so high that he is unable to know the nature of the act, right? And there is a CCTV footage that he had hold a wallet of some other person. He had watched it and kept it in his pocket. The very next day, the same wallet was found in his possession. Now you have to tell me whether he will be liable for committing theft or he will be acquitted.
So he won't be acquitted because the general exception of Chapter 4 says that under Section 84 of the Indian Penal Code, only that
84?
person could be
Are you sure?
84 of IPC, sir. Voluntary intoxication, sir, if he has willfully uh, uh, has been drunk, then anything done would not be exempted from the liability, sir.
Don't you think it is 85?
So voluntarily, I believe it's 84.
And what is unsoundness
Sorry,
then?
84 is insanity, 85, sir.
Okay. Okay. So according to you, that person will be held liable for committing theft?
Yes.
What is the mens rea and the actus reus of theft?
So actus rea would be taking the purse, but mens rea would be that even at that time, so I don't think that his mind is capable enough to constitute a mens rea. But the fact that he has looked at the wallet and still kept it, that could be
Mhm.
construed as mens rea.
So how can, if you are not able to prove the mens rea, that person can be held liable? Because in order to prove guilty, you need to prove actus reus as well as mens rea.
So, but the circumstances is as such that
Under which provision that circumstances can be imagined or presumed?
I'm unable to recall the any provision
No
of
worries.
circumstantial evidence.
No worries. Okay. You might have studied the Transfer of Property Act. What do you mean by charge?
Chart. So the section 100, if I'm not wrong, is talks about charge, and it mainly says that charge includes the any head of charge, but charge basically means that any encumbrance on the property which is transferred,
What do you mean
that is
by
charge.
any encumbrances?
So any debt or liability that has been attached to such property that has to be paid would be termed as encumbrance.
Uh, do you know Hakshufa? Can you
Shifa.
elaborate what is Hakshufa?
So I am not really sure, but if you permit, I can guess.
Please.
So I believe it's the right of preemption.
Mm-hmm.
So if there is a person who is connected to the property in any way, such as it could be a neighbor or a relative or so, and if such person, if a property which is connected to
How
that
a
person,
preemption, that is Hakshufa, is being dealt under Muslim law?
I've not yet read the Muslim Succession Act. So
That was not your optional subject?
yes, it was.
It was. Okay. Okay. And according to you, what is meher?
The meher is a consideration which is to be given to the wife by the husband for marriage.
What are the types of meher?
So it could be prompt meher, it could be a deferred meher. Prompt meher or a specified meher or unspecified meher as well.
What
So
is
prompt,
meher musamma?
I'm unable to recall the exact
Meher
terminology of it.
muajjal?
I believe it's deferred dawa, sir.
What is deferred dower?
Deferred dawa could be given after the dissolution of marriage or at any later time that has been agreed by the parties.
Whether Muslim marriage, Muslim nikah, is a contract, and if yes, how it is different from Indian Contract Act?
So it is considered to be a contract because it has all the aspect of contract act, such as
All the
all the
aspect?
not all. It has the aspect of Indian Contract Act, sir. So it has a proposal, it has acceptance, it has a consideration, and but sir, it can't be because there is some difference when it comes to the age, the competency of marriage. There are certain situations in which the permission of marriage could be given by the guardian, which is not to be done in Indian Contract Act. The age of the parties could also be deferred because there the issue is of puberty. But in under Indian Contract Act, it's a strict 18 years of age. Majority age is required for any contract.
That minors agreement is void ab initio.
Yes.
Is there any provision related to it? Any provision, any statutory law that minors agreement is void ab initio?
So Section 12 of Indian Contract Act says that
What
the
it
party,
says?
the person to enter into a contract must be of major of must be
So
major.
whether it also declares that such agreement is void?
So the case of Mohiri Bibi versus Dharmadas Ghosh is one of
That
such
is the
that says that
precedent. That
the
is the
precedent. Yes,
precedent. I'm asking
yes.
about the statutory provision.
So I'm unable to recall the. I believe it's Section 12, but I don't think it has void ab initio as a wording.
Okay.
Yes.
Okay. All right. what do you understand by the term precepts?
Precept. So precept is a command by one court to another court if the property of the other person, the judgment debtor, has been situated in the other court's jurisdiction. Then one court gives the command to other court to attach such property until the matter has been finalized in this court.
How gift in TP is different from gift in Muslim law?
Uh, Unable to recall.
Okay, all right, no problem. You have you studied the company law?
Not yet. So I have studied arbitration though.
Arbitration. Okay,
Yes.
all right. So you might have studied it in your college.
Yes, sir.
So what is memorandum of association, if you may recall?
The memorandum of association talks about what rules and regulations the company would have to follow. And
What is brochure?
so brochure is what I'm unable to recall it.
Okay, okay. And what are the situation of subsequent voidability in Contract Act? Please give me some situations.
Subsequent voidability. For instance, if there was a law valid at the time of the contract, but later on the law is changed. For instance, in Bihar, if there is a liquor factory which has been established when the law was in force, but later on the law got changed, so it would be an illegal contract that would be frustrated.
No, my question is subsequent voidability. What you have answered is subsequent void agreement. My
Void
question is voidability.
voidability.
That contract becomes voidable.
Can I take a moment, sir?
Yes,
Uh,
please.
Okay, so if two person have agreed to transfer a property, and due to okay, they have
You might
agreed
have
to
studied time is an essence.
yes, sir.
And if suppose that contract is not performed within the time, then what will happen? The
So
nature of contract.
it would be on the option of the party who have suffered any loss to
So
whether to
that means that it is a voidable contract. It
yes, sir.
becomes a voidable contract.
Yes, sir. It
So in
gives the
starting, it
chance to the
was
agreed.
a valid contract, but the promisee is unable to perform within the time frame, then it becomes voidable. So that is subsequent voidability, right? Okay. Okay. What is the difference between void agreement and voidable contract?
So in void agreement, the agreement was void ab initio. But in voidable agreement, the agreement was started as valid agreement, but due to some circumstances, or because that was initiated when someone uh, has not done had done so with free consent, then that would be termed as voidable contract.
You might have came across the maxim nudum pactum.
Yes, sir.
What is it all about?
Uh, so if there is no consideration in the contract, it would be a void contract.
It will be a void contract,
Void agreements.
void agreement or void contract.
The agreement can't be. It has to be void ab initio. It would be an void agreement.
Void agreement. Okay. All right. There are, however, certain exceptions also associated to it, and under which provision it is given.
Because Section 25 uh, talks about three circumstances in which an agreement without consideration would be valid.
How contingent interest and conditional interest are different in respect to Transfer of Property Act.
Conditional and contingent. So contingent interest could be termed as anything which has to be depend on the happening and non-happening of an event. When it comes to conditional interest, it has to be on the basis of doing something after the transfer has been done. Section 20, I believe it's conditional subsequent.
You
Section
can answer.
28.
You are having a liberty to answer whatever you want.
Yes, sir. So section 29, if I'm not wrong. I'm confused between section 28 and 29, sir. That talks about conditional subsequent, which says that if a transfer has been done and any condition attached to it has to be performed strictly after such transfer has been
What
done.
is marshalling?
So
By
marshalling
subsequent
is
purchaser.
subsequent purchaser. Okay. So that has been mentioned under section 56, which says that if the property, if there are two, it's a settlement of sorts, sir. That if a property has, I'm wrong. Sorry. But
You may continue.
I'm unable to recall it.
Just a minute. Over here. All right, Farah, it was good today, right? I'm concluding it. We shall meet some other day. However,
Thank you.
I'll just wait. I'll be giving you the feedback, okay? Just a moment.